Ladies and gentlemen, session 2 begins shortly. Please kindly take your seats. And also the moderator and panelists for session 2, please kindly proceed to the stage. Thank you. Ladies and gentlemen, session 2 will begin shortly. Please take your seats. As a courtesy to other participants, please put your mobile phone on vibrate or silent, but do not turn it off because in this year's conference, we're going to ask for interactive audience participation at several points. We ask the audience to serve as the jury for panel discussions. Please see if you have a piece of paper on your table in front of you. Also, if you entered your cell phone number at the registration, you should have received a text message. Click the link on the text message or use the QR code on the paper to fill out the survey for session 2. Please submit your response by 3:30. We will check out the result at the end of the session.
Welcome back, everyone. We are about to start second half of today's schedule. We have 2 afternoon sessions with a break in between. Buckle up tight, as both sessions deal with a highly important issue in today's IP dispute. Anyway, did you enjoy your lunch? Yes, you enjoy your lunch. Yeah. For those of you from abroad, it may have been first time to taste kimchi. Kimchi is one of the most famous Korean food. Kimchi has many trademarks like this. And you probably heard of Gangnam, very popular area in Seoul. It gains international fame thanks to this song.
오빤 강남 스타일. 강남 스타일. 오빤.
What if I try to register a mark named Gangnam Kimchi after my name Gangnam? Is it fair? Is it illegal? This is why you should focus on session 2. Moderator of session 2 is Honorable Presiding Judge Jejeong Lee of Patent Court of Korea. Please join me welcoming him.
Good afternoon. It's my great pleasure to be the moderator for session 2 of today's conference. We dealt with quite heavy topics in session 1, such as Makushi type claims, or means plus function claims, and product by process claims. But changing the atmosphere, session 2 will cover a less heavy and very exciting subject: lawful exercise of trademark rights. Each country's trademark law system has its own characteristics, but resembles other countries' systems at the same time. Furthermore, with the development of the internet and mobile search technology, the number of cases that are not compatible with the traditional concept of trademark use increases, along with the need for adapting existing trademark theories to the change. In this slide, it will be very meaningful to discuss different countries' trademark law systems. Before we start, let me introduce our panelists who have taken their precious time out of busy schedules to come here. As I introduce the panelists one by one, please give them a big round of applause. To my immediate left is Judge Byeongguk Kim. He first took bench at Ansan branch of Suwon District Court in 2008 and came to the Patent Court in 2017. Please give him a big round of applause. Now, High Court Judge Donggyu Kim with us. He first took bench at Busan District Court in 2002 and came to the Patent Court in 2016. Please give him a big hand. Next to Judge Kim is Judge Takafumi KOKUBU. He is at the IP High Court of Japan. Please give him a big hand. Now, Judge Hong Liu is with us. He is at the Guangzhou IP Court of China. Please give him a big hand. Next, Chief Judge Leonard with us. As introduced in the keynote session, he is at the United States District Court for the District of Delaware. Please give him a big hand. Lastly, but not leastly, Mr. James Saintville is with us. He's an experienced barrister specializing in IP, including patents, designs, copyright, and trademarks in the United Kingdom. Please give him a big hand. Now, let's get started. The first topic is distinctiveness of trademarks, in particular, the standard of distinctiveness. I would like to start by asking Judge Stark and Judge Byeongguk Kim the first question. A trademark is an identifying mark used to indicate the source of the products. Therefore, distinctiveness is required for trademark registration. In deciding the distinctiveness of trademarks, the question is whether it is appropriate to grant an exclusive right to a specific person, which is called adequacy for exclusivity test in Korea. In your country, is adequacy for exclusivity considered when determining whether a mark is distinctive? Let's first hear from Judge Stark.
Thank you very much, Judge Lee, for the question. I would just first say as a preface, whereas you may have heard me say this morning, I have between 200 and 300 patent cases on my docket at all times. It is not the same for trademark cases. I usually have between 3 and 5 on my docket at the same time. So this is all a little bit different for me. But I've been very happy to learn more about international trademark law. I'm looking forward to hearing from the others on the panel and to telling you about U.S. trademark law. So to answer the question, we do not have the concept of adequacy for exclusivity per se under U.S. law. Instead, we have a similar concept called secondary meaning. What do I mean by that? In order to have a trademark in the U.S., you need to have distinctiveness. And there are two broad classes of distinctive trademarks under U.S. law: inherently distinctive marks and marks with acquired distinctiveness. So an inherently distinctive mark is one that prospective purchasers are likely to perceive as a designation that identifies goods or services produced or sponsored by a particular person. So for instance, if something is fanciful, arbitrary, or suggestive, we consider that to be inherently distinctive. But a trademark that is not inherently distinctive may nevertheless be valid, and that is, in order to do that, one has to demonstrate that the mark has secondary meaning, meaning that the mark has become distinctive in that as a result of its use, prospective purchasers have come to perceive it as a designation of a source. A descriptive mark is only valid if the claimant establishes that the mark does have a secondary meaning. So while we don't specifically have the concept of adequacy for exclusivity, I do think that our concept of secondary meaning and acquired secondary meaning is quite similar. It turns on the real-world use and real-world understanding of the words and the concepts in the mark as opposed to just its dictionary definition.
Thank you, Judge Stark. Judge Byeongguk Kim, will you share your views on this issue?
네, thank you very much for giving me the word. For the sake of saving time, let me answer to the question number 2, the adequacy of exclusivity. As a judge of the Patent Court Korea, sometimes we face with the question whether it is right or suitable to grant an exclusive right to a specific person, especially when many other persons use the same trademark or mark, or others has already have trademark right with the same part. This is the fact as called etiquette of exclusivity. The Supreme Court of Korea makes it clear that is one of the key factors when deciding to grant trademark right. The detail of this decision is written on the page 127 on the English reference book. Please refer to this reference book later. As indicated in the Supreme Court precedent, it is deemed unsuitable to grant an exclusive right to a specific person for the sake of public interest. Furthermore, we Court of Korea take into consideration of the adequacy for exclusivity when deciding the similarity between the compared trademarks. This issue is going to be discussed later when we deal with the so-called prominent part. But when deciding some specific part of a trademark is prominent or not, we take into consideration of the exclusivity. There is a very interesting case on this regard. The trademark at issue was Monster Energy, which is a very renowned company of energy beverage. The issue was that whether the Monster part, the part Monster, is prominent or not. And the Monster Energy Company claimed that the Monster is a prominent part of this trademark. So the trademark of the dependent has the same part, the Monster. So the two trademarks should be decided similar with each other. However, in accordance with the submitted evidences, the court finds that there are so many trademarks already exist or used by the third part that includes Monster, such as Mango Monster, Lotte Monster, Monster blah blah. So the court decided that Monster is not appropriate or suitable to get the exclusivity protection. So the observation should be, the comparison of the trademark should be overally observed. So the two marks is not similar with each other. So that's it for the adequacy for the exclusivity. Thank you.
Thank you, Judge Kim. Next is about descriptive marks. A descriptive mark is not eligible for trademark registration because it makes the quality and property of the relevant products or services perceived intuitively. It would be great if Judge Stark and Judge Donggyu Kim can share their opinions on this question with us. How does your country define a descriptive mark? Is there any standard adopted by the court when determining whether a mark is descriptive? Let's first hear from Judge Stark.
Yes, thank you for the question. We do not have a statutory definition of a descriptive mark, and one thing to understand about U.S. trademark law is there's a federal statute called the Lanham Act, but then states also, this is an area where each of our 50 states is permitted to legislate, and many of them have trademark laws as well. But it is left ultimately to our courts to interpret those statutes and to therefore define what is a descriptive mark. And a pretty standard definition, one from the Federal Circuit, is that a term is merely descriptive and therefore not eligible for being a trademark if it immediately conveys knowledge of a quality, feature, function, or characteristic of the goods or services with which it is used. It's not a bright line, black and white test. It's a flexible standard that's evaluated in relation necessarily to the particular goods and the particular market for which the registration is sought, and with an important understanding or attempt to understand what an average purchaser of the goods would understand from the use of the mark. So it's ultimately a judge-made and judge-interpreted standard that has some flexibility to it.
Thank you, Judge Stark. Judge Donggyu Kim, please share your views.
Thank you. The Trademark Act of Korea defines a descriptive mark as a mark consisting solely of the part indicating the place of production, quality, raw materials, effect, usage, quantity, shape, price, method of production, method of processing, method of use, or time of use of goods in a common manner. This definition suggests two requirements for a descriptive mark. One is that the mark indicates the nature of a good product, such as product, and the other is that it consists exclusively of such descriptive part. Concerning the first requirement, the Supreme Court held that if the consumer of the goods intuitively perceives the nature of the goods from a mark in consideration of the goods, the mark can be said to be indicate the nature of the goods. Indicating in a common manner means that the apparent composition and the use method of the mark do not attract consumer special attention. In the case of a designed descriptive word mark, it means that the design of a mark attracts consumer special attention, so the impression of the design of a mark overwhelms perception of the word of the mark to the extent that the descriptive meaning of the word cannot be intuitively perceived. When it comes to a second requirement, is main arising dealing with cases of composite marks. As for a composite mark, which is composed of descriptive parts and other distinct elements, may not be evaluated as a descriptive mark because the mark does not consist exclusively of the descriptive part in a common manner. In spite of these tests, it is very difficult to distinguish a descriptive mark from a suggestive mark in real cases. Thank you.
Thank you. Next question goes to Mr. Saintville, Judge Liu, and Judge KOKUBU. Based on your email response to the questionnaire, it appears that you came up with different conclusions on the descriptiveness of the marks Primewell for tires and color wearing for lipsticks and nail polishes. Could you elaborate a little more on this matter? Let's first hear from Mr. Saintville.
Thank you for that interesting question. More interesting from my point of view, again, because the answer that I'm going to justify is the answer of Sir Robin Jacob, who says that both marks are inherently distinctive and not descriptive. And when I looked at them, I reached the same conclusion as him, but for different reasons, and it's to an extent. And it's interesting just to talk through and think through those reasons. To understand the reasons, you need to understand the structure of trademark law in Europe and the UK, because we have a national law that is partly harmonized through Europe as a result of the Trademark Directive that has now gone through 3 versions from 1989, 2008, and 2015, but fundamentally saying the same thing, the same rules just adjusted going through time. And we have a 1994 Trademark Act that implements that. And then there is a pan-European trademark system, the European Union trademark system, which is set up by regulations that have gone through the same series of variations and set up a unitary trademark for Europe. And the substantive rules on whether a trademark should be registered are the same, just set out in different legislative instruments with, unfortunately, different article numbering. And the question of distinctiveness is dealt with in, for instance, Article 4 of the most recent Trademark Directive, which provides that signs mustn't be registered in this respect, first of all, if they cannot constitute a mark, which means that they're not capable of distinguishing between trademarks or distinguishing between goods and services from different undertakings, or aren't capable of being represented on the register in a way that is clear and precise. Secondly, if they are devoid of distinctive character. And then thirdly, if they consist exclusively of signs or indications which may serve in trade to designate the kind, quality, quantity, intended purpose, and there are other examples, or other characteristics of the goods. And then finally, trademarks which consist exclusively of signs or indications which have become customary in the current language of the trade. And those last three can be overcome if distinctiveness is shown through use. So that picks up the same concepts as Judge Stark was talking about earlier. When it comes to then looking at a mark that's a combination of words like Primewell or colour wearing, the way the courts approach the problem is to work backwards through those lists so that it's clear that these aren't signs that are customary in the trade. Do they consist exclusively of signs which may serve in trade to designate the kind, quality, or other characteristics of the goods? Well, you look at the words and their potential meaning. Sir Robin Jacob thought Primewell was a combination of primed and well. I think to myself, well, is it a combination of prime, which might be laudatory, and well, which might be laudatory? But what's that meaning? What meaning do those words have in relation to tyres? And the conclusion is, well, you don't talk about priming tyres. You don't talk about priming tyres well. You might pump them up well. And so there's nothing that's specifically descriptive, and there's nothing there that's devoid of distinctive character as well. That's why we reach the conclusion that that's a mark which is prima facie capable of distinguishing the source of goods, the goods in question. And the same for colour wearing, because you wouldn't ever refer to lipstick or nail polish by a description of colour wearing, or use terminology in that respect. And an interesting comparison might be an English case that the mark was cycling is ... And that mark was held not to be descriptive in the sense of consisting exclusively of signs that might serve in trade to designate the kind or quality of goods, but because it invited the reader to fill in what cycling is in relation to cycling goods, but it was held to be devoid of distinctive character because when used, it's not capable of without it's not capable without the public being educated of distinguishing goods coming from one undertaking from another.
Thank you, Mr. Saintfield. Judge Liu, will you share your views?
First, I must use my translator. Please, very sorry. 对于第一个标识来讲，我认为它的根据词典的基本含义呢，是包含了这个好的意思，所以从 基本的含义来讲，它包含了一个好的意思的描述。
For the first sign, I think the basic meaning of its dictionary contains this good meaning, so from the basic meaning, it contains a good description of consciousness.
同时，如果它在使用中经过一定时间的使用，它包含了这个第二的含义，或者是具有使用的历史，可以作为区分商品来源的作用。那这种情况下，可能会认为它不具有这个描述性。
At the same time, if it has been used for a certain period of time, it contains the second meaning, or has a practical history, which can be used as a function of distinguishing the source of goods. Then it may be considered that it does not have this descriptive nature.
对于第二个标识，它是用于唇膏和指甲油的类别。对于这类产品，它肯定是一般来讲具有某种的颜色。
For the second logo, it applies to the category of lipsticks and nail polishes, for which it must generally be a certain color.
但是从这个第二个标识来看呢，它并不是对于产品具有某种颜色或者是这个具有颜色这一个特点的描述，所以就我个人认为它具有一定的这个识别性，不是纯粹的对于使用的类别的商品的一种描述。
But from this second logo, it is not a description of the product with a certain color or a color characteristic, so I personally think it has a certain recognition, not a pure description of the type of goods used.
Oh, thank you.
Thank you, Judge Liu. Judge KOKUBU, will you answer for this question?
Thank you for your giving also me the opportunity to explain the ground for my email. So, as for primeware, I thought it's not descriptive. Both prime and wear are supposed to indicate degree of quality regarding the designated goods tire. However, these two words are written in all capital letters with equal spaces between the letters. So it has an appearance of one word and does not have particular meaning as one word. Therefore, I concluded primeware was a coined word and not descriptive. On the other hand, the color wearing is written in general form. It indicates to wear a color, which is the effect or the usage of the designated goods, lipstick and nail polish. Therefore, I thought it was descriptive. Thank you.
Thank you for the helpful answers. The next question is about disclaimer statement. I would like to ask Judge Stark, Mr. Saintville, and Judge Byeongguk Kim. In some countries, an applicant is required to declare at the stage of trademark registration that he or she will not exercise the right based on low distinctive or indistinctive parts of a mark. Does your country require an applicant to disclaim an unregisterable component of a mark? Let's first hear from Mr. Saintville.
This is particularly timely and an interesting question from a UK law point of view. The answer so far as UK law is concerned is that in our Trademarks Act, in section 13, the Act says that an applicant for a trademark can disclaim any right to exclusive use of any specified element of the trademark and or agree rights conferred shall be subject to a specific territorial or other limitation. Now that was the law introduced in 1994, and our trademark registry, having previously had the practice that it could require a disclaimer to be made, came to the slightly odd conclusion that it couldn't use that provision to require a disclaimer for registration, even though the registry is in discussion with an applicant for a trademark. So it might say, well, you can't have that registration unless you offer a disclaimer. And so the English law went along for the last 25 years operating on the basis that disclaimers were used in a rather erratic fashion, but when they were used, there was case law that said that that was binding, and therefore the matter disclaimed was left out of consideration when it came to questions of both infringement and validity compared to later marks being applied for on the register. The practice across European-wide trademarks, community trademarks that are now called EU trademarks, was less clear because there was no express provision in the legislation for disclaimers, and the European Union Intellectual Property Office was not attracted to them and in general negative towards them. But that landscape was created because the European project of harmonizing trademark law was only aimed at partial harmonization. So there's harmonization of the provisions that deal with validity of trademarks, whether you're entitled to apply for a trademark, and infringement, but not of the procedure for application. And the change that has happened in a case in the European Court of Justice, which is the PRV against Hansen, that's the Swedish Patent Office against Mr. Hansen, arises out of that partial harmonization, because the same setup, basic setup, was in place in Sweden, where you can have disclaimers, and the question was, if once there had been a disclaimer, what was the effect on the relative grounds for refusing registration of a later mark, and similarly infringement. And for that purpose, it's easiest for me to hold up so that you can see the trademark in question. So the trademark in question is Roslag's Punch, with a picture of a boat at the bottom, and the disclaimer disclaimed any exclusive right to use the words Roslags or Punch, because Roslags is the name of a place and Punch was the kind of drink involved. And the question was, when Mr. Hansen applied for the trademark Roslag Sol, whether the words Roslag and Punch should be taken into account in deciding whether Roslag Sol was registrable. The result was that they should be taken into account, and the Court of Justice reasoned in this way, that the test of comparison between a later application and an earlier application is one of global appreciation, taking into account all relevant factors. Now, if you're considering a complex composite mark, then you've got to take into account any descriptive elements so that you can understand the context in which the distinctive elements are used. What's more, the reasoning goes, that if you leave parts of a mark out of consideration, then what happens when they become distinctive through use? You're now carrying out an artificial exercise and excluding permanently and at the outset something that may be relevant to whether members of the public are going to be deceived and confused later. And as I understand it, that has some parallels with the way in which disclaimers are dealt with in the United States. So the end result is that the Old English law on the effect of disclaimers is likely now to be swept away, and it's difficult to see what effect a disclaimer has on the enforcement of a trademark later, except to say, well, one thing to be taken against you as the trademark owner is, at a certain date you accepted that parts of your mark were not distinctive.
Thank you. Judge Stark, what is your views on this issue?
Thank you. I do think it is quite similar to what was just described in the UK. Our statute, the Lanham Act, does authorize the Trademark Office to require a disclaimer if it's going to make a mark that would otherwise be unregisterable registrable. And that would typically occur when you have a composite mark, so a mark that consists of, you know, 2 words, for instance, like the one we were just seeing from the UK example. It may be that each of those words on their own are merely descriptive, but there's an argument that the combination of them is not merely descriptive and therefore could be distinctive and registrable. In that circumstance, our Trademark Office does and most likely will require a disclaimer before considering whether to allow the mark to be registered, and then that disclaimer would have effect as one tried to use the mark in commerce or litigate it later.
Thank you, Judge Stark. Judge Byeongguk Kim, will you answer for this question briefly?
Thank you. Thank you for giving me the bar. In Korea, we did have this system, disclaimer, but when the Trademark Act was enacted for the first time in the year of 1949, it was 60 years ago, very long time ago, but it was abolished in year 1973. The reason of the abolishment is unclear, but there was an opinion that it was a concern for the extra burden on the examination, and it was believed that other clauses of the trademark law would bring the same effect. Disclaimer statement, to my thought, can play a very productive role today, where there is a high demand for use or have the trademark for the good mark. On the other hand, the good mark is a limited resources, which is going to be depleted as more and more trademark is occupied by the others. So disclaimer is a very good system to satisfy this high demand without hampering the interest of the others. In this regard, the judges can take measures which result in the similar effect of the disclaimer. The court which I belong handled a case where it was a revocation case due to the rejection by the PTO on the ground that the trademark is not distinct enough. And the plaintiff stated in the courtroom that he doesn't have any intent to exercise his right on the basis of the indistinct part. So we reflected his statement on the protocol of the pleading and allowed the registration. Thank you.
Thank you. The next question is about acquisition of distinctiveness through use. Even an indistinctive mark, such as a descriptive mark, can be registered when such a mark has acquired distinctiveness. Does your country allow the registration of marks with acquired distinctiveness through use? If so, what are the standards for deciding whether a mark at issue has acquired distinctiveness? Let's first hear from Judge Stark.
Yes, thank you. Our system does allow for that. That's that second broad category of getting a mark that I referenced earlier. Acquired distinctiveness, or also we call it secondary meaning. One can establish that secondary meaning through either direct or circumstantial evidence. Direct evidence would be, for instance, if you have a survey of what actual consumers understand that the purported mark is signifying. More common, of course, is circumstantial evidence, and that could include anything that does somehow shed light on the question of whether consumers have come over time to associate the particular mark with the claimant. Some examples that we see are records of online search results, the use of the mark in advertising, the amount of sales and the types of goods and services that the mark allegedly relates to, and very importantly, any evidence of actual confusion that may be associated with the mark.
Thank you, Judge Stark. Judge Donggyu Kim, will you answer for this question?
The Trademark Act of Korea allows explicitly to register the marks with distinctness through use. If indistinct mark has been used as the indicator of the specific source of a product exclusively, continuously for a substantial period of time, so the mark is sufficiently recognized as the indicator of the specific source of the product by consumer and traders of the goods. The mark works as a trademark and lose the necessity to allow anyone to use it fully for the sake of public interest. Therefore, granting registration for the mark is not against the purpose of the Trademark Act, which aims to protect the interests of trademark owners and consumers. A mark should meet two requirements in order to be registered as a mark with acquired distinctiveness through use. One is that the mark has been used before its application date, and the other is that the mark is sufficiently recognized as an indicator of a particular source of the product by consumers and traders of the goods. In other words, the mark can identify the source of the goods. But there is no specific criterion set for the period of use. Thank you.
Thank you. Due to the time limit, we should round out our discussion on this topic. Let's move on to the next topic. The second discussion topic is determination on similarity between trademarks. I would appreciate inputs from Judge Stark, Judge KOKUBU, and Judge Byeongguk Kim. Similarity between two marks is a crucial issue in trademark infringement cases as well as registration cases, and most of trademark trials involve this issue. Could you introduce the standard for deciding similarity between two marks in your country? And further, do you focus more on the sound than the appearance or meaning when deciding the similarity between the two marks, which are composed of letters? Let's first hear from Judge Stark.
Yes, thank you. So certainly the similarity between marks is a key issue at every step in the U.S. system. Our law does prohibit the registration of a mark that is likely to cause confusion, and the more similar the marks are, the more likely they are, of course, to cause confusion. And trademark infringement is also largely turns on likelihood of confusion or demonstrated actual confusion. So again, similarity of the marks is of great importance there. We have a number of different articulations of the standard for assessing whether two marks create any likelihood of confusion. Among the factors that most of our courts will consider are things such as the strength of the plaintiff's mark, the degree of similarity between two marks, the proximity of the products, evidence of actual confusion, and the defendant's good or bad faith in adopting its own market, as well as issues relating to the sophistication of the typical buyer and, for instance, how expensive and how much thought goes into the purchase of the good that is at issue in connection with the mark. On whether sound is particularly important in assessing the similarity of the marks, our courts mostly talk about sound, sight, and meaning as being the trilogy or the three sub-factors that are considered, and typically no one of those three takes on any greater importance than any other. Just as a general matter, the more similar two marks are when either heard or seen, or the more similar their actual dictionary definition meaning would be, the more likely it is that consumers will be confused. Therefore, the less likely you can register the new mark, and the more likely one would find infringement in circumstances where that was brought before a court. But again, we do not tend to emphasize one sub-factor over any other. We take a more holistic approach and consider the sound, the meaning, as well as the sight.
Thank you, Judge Stark. Judge KOKUBU, what is your views on this issue?
The Supreme Court precedent provides a standard for deciding similarity. The similarity is determined based on whether there are concerns for consumers to confuse the source of the goods when the two marks are used for identical or similar goods. It should be determined by comprehensively considering impressions, memories, or suggestions given to traders invoked by appearance, concept, and sound of the trademark. The Supreme Court also says that so far as the actual condition of the trade of the goods can be relieved, it is appropriate to make judgment based on the specific situation of the transaction. In Japan, sound is not necessarily considered more important than appearance and concept. The Supreme Court precedent states that appearance, concept, and sound should be considered in a whole and overall manner.
Thank you, Judge KOKUBU. Lastly, Judge Byeongguk Kim, please share your views.
Yeah, thank you. The practice of Korea is very similar with that of US and Japan. So let me add three points on this regard. First, there is no specific word or requirement in the Trademark Act of Korea, the word confusion or likelihood confusion. But the Court of Korea makes clear that confusion or likelihood or concern of confusion is one of the essential factors for determining similarity of the marks. The second point is that regarding the method of comparison, the principal method is overall observation of the two marks at issue. But sometimes this overall observation leads to the wrong or that doesn't like fair conclusion. So to supplement this principal method, court adopts method of comparison based upon prominent part, when there is a prominent part in a composite mark. Lastly, in my opinion, it's my personal opinion, but there are three factors: sounds, appearance, and meaning when comparing the similarity of two marks. But in my opinion, in Korea, sounds plays more important roles than other two factors, that is appearance and meaning. Yeah, that's it.
Thank you. Next question is about determination based on prominent or dominant parts. It would be great if Mr. Saintville, Judge KOKUBU, and Judge Liu can share their opinions on this question with us. When determining the similarity between the two marks composed of multiple components, there is a view that the focus of comparison should be the particularly distinctive parts, that is, prominent or dominant parts of the marks at issue. Do the courts of your country take this approach? If so, please introduce the standard adopted by the courts. Let's first hear from Mr. Saintville.
Thank you. There's a simple answer to this question, which is when assessing likelihood of confusion, which is a requirement of infringement in one of the three kinds of infringement you can have under European trademark law, then of course the more prominent parts of the marks matter, because those more prominent or distinctive parts of the mark are, if similar between two marks, are more likely to be confused. The way that Robin Jacob puts it in his pithy style is it's not a question of law at all, it's a question of fact. And when you unpack the reasoning of the European courts, and our many cases, you see that that is the case, because likelihood of confusion has to be appreciated globally, taking into account all relevant facts. That has to be judged through the eyes of an average consumer, and that average consumer, although reasonably well-informed and reasonably circumspect and observant, rarely has the opportunity to directly compare marks, so they have to bear in mind the picture of the mark as it stays in their mind, their imperfect recollection of the mark. And of course that comparison is done by visual, oral and conceptual aspects of the mark and their visual, oral and conceptual similarities. But that all should be done bearing in mind the distinctive and dominant parts of the mark. And when you then look at the jurisprudence about that, you see that sometimes comparison that tends to concentrate on those distinctive and dominant parts is justified, and sometimes if there's a very dominant part of a mark, then concentrating on that can be justified. Why the range of variations? As Robin Jacob says, it's because it's all a question of fact. How will the consumer respond to the two marks in all of the circumstances?
Thank you, Mr. Saintville. Judge KOKUBU, what is your views on this issue?
In accordance with the standards set by the Supreme Court precedents, making comparison to a certain part of the mark is allowed when the part provides strong and dominant distinctiveness, when the other parts are particularly less distinctive, and the components of the mark are not considered inseparably combined, that comparison by element is deemed unnatural in transaction. The element to be focused is called the essential part in Japan. For example, when a trademark includes generic mark of goods or services, a part other than the generic mark usually becomes the essential part. When a composite trademark includes descriptive mark, the part other than the descriptive mark is often regarded as the essential part. When a composite trademark is a registered trademark, well known as a trademark of somebody else, combined with other characters or figures, the registered trademark is considered as the essential part, and the composite trademark at issue is treated as similar to the registered trademark of somebody else.
Thank you. Judge Liu, please share your views.
Okay. 中国法院在判断商标的相似性的时候，是以普通消费者的一般注意力为标准，既要对商标的整体进行比对，同时也会对商标的主要部分进行比对。
When Chinese courts judge the similarity of trademarks, they take the general attention of ordinary consumers as the standard, not only to compare the whole trademark, but also to compare the main parts of the trademark.
法庭会特别关注这个突出使用的图案、文字等在整个标识中所占的比例，以及它突出使用的情况。
The court will pay special attention to the proportion of the highlighted text in the whole logo and the situation of its prominent use.
法庭在关注整个标识的整体比对的时候，同时会考虑请求保护的商标的显著性以及知名度，还有已所涉的商品类别等这些因素综合考虑。
When the tribunal focuses on the overall alignment of the logo, it takes into account, inter alia, the request for protection, the salience and visibility of the trademark, and the type of goods involved.
Thank you. Thank you. Next question is about likelihood of confusion. I would appreciate inputs from Judge Stark, Mr. Saintville. Even if two marks look similar in appearance, sound, or meaning, they are not likely to be similar in case there is no likelihood of confusion on the source of the products. And further, it matters whether the confusion should be viewed as actual confusion or not. In this regard, could you explain the trial practice in your country? Let's first hear from Judge Stark.
Yes, thank you. In the United States, the key here is likelihood of confusion, and we find that consumers are most likely to be confused where a mark is used by a direct competitor of the mark's owner. However, a company using a mark may infringe even if it is not a direct competitor to the mark's owner, if the products or services being offered are sufficiently related. And there's much litigation and, as you would imagine, some disagreement in outcomes in terms of what products are found to be related. For instance, courts have found that syrup and flour, beer and cigarettes, and beer and scotch are related to one another, that is, in those pairs. I'm not suggesting all 6 of those are related to one another. But if two marks used by different entities are similar, but used on entirely different, that is, not related products or services, then the law generally presumes that there's little likelihood of confusion. And one case in that regard involved a fishing company that was found not to infringe a mark despite using an essentially identical mark to one owned by a dairy company, because the court found that the industries the companies were competing in, or not competing, that is, were operating in, fish versus dairy, were not sufficiently related. In terms of trial practice, when these issues play out in court, of course, each side gets an opportunity to present evidence on all of the points here that I have referenced, relatedness and likelihood of confusion. There's all the extensive pretrial proceedings that I referenced in my remarks earlier this morning in regard to patent litigation. And one particular type of evidence that we sometimes see is survey evidence, which might be used at trial to establish issues such as secondary meaning and likelihood of confusion, and in some instances dilution of a trademark. And in general, subject to the Delaware motions that I referenced also this morning, that is the qualifications we place on expert opinion testimony, subject to review under those Daubert standards, it's typically the case that survey evidence, if done by a proper, reliable methodology, is admissible in federal court in order to try to show likelihood of confusion.
Thank you, Judge Stark. Mr. Saintville, will you answer for this question?
Yes, of course. One has to, first of all, look at the legal requirement that's being considered. So the provisions of the trademark directive refer to where, because of the identity with or similarity to the trademark and the identity or similarity of the goods or services covered by the mark, there exists a likelihood of confusion on the part of the public. Now, that likelihood of confusion, because of those two causes, is interpreted as a risk that the public might be deceived as to whether the goods or services come from the same undertaking or an economically linked undertaking. That means that you can have direct confusion because one mark is confused for the alleged infringing mark, or you can have indirect confusion because the similarities in the mark lead to a mistaken belief that the goods or the services are coming from linked undertakings. It could also include the possibility that somebody who knows a business that they're dealing with that uses a particular mark and then later comes across the earlier trademark owner and being confused in that way amounts to trademark infringement. That happened in an English case about the trademark Glee Club, where that was the trademark of a comedy club, but the US television series of the same name then coming into the UK caused that kind of likelihood of confusion, even though their customers may have known about their television series before they came across the comedy club. It may also be post-sale confusion, so not the possibility that somebody will be confused at the point of sale, but after the goods or services have been sold. Now that is all assessed by the kind of global appreciation that I talked to you about before, where there is an interaction between the various elements of the background. So a greater similarity between the goods and services can overcome a lesser similarity between the marks. And evidence of confusion actually taking place is, of course, very powerful, an indication that there's a risk of confusion, a likelihood of confusion. On the other hand, the absence of confusion doesn't necessarily lead to the conclusion that there's no likelihood of confusion, because there can be all sorts of reasons as to why there's no confusion. But there are example cases where if parties exist on the marketplace, coexist on the marketplace for long periods of time without confusion, then it becomes harder and harder to explain away the lack of confusion while still saying that there's a risk or a likelihood of confusion. And a well-known example of that is the case where two banking businesses were in coexistence for some 8 years, Stichtung BDO and BDO Unibank. And the judge reached the conclusion that that long coexistence made it difficult and in the end impossible to reach the conclusion that there was a likelihood of confusion between two marks that might otherwise have seemed similar.
Thank you, Mr. St. Ville. This question goes to Judge Stark. In the United States, especially in case of a famous mark, it appears that dilution theories such as blurring and tarnishment have been established for years separately from likelihood of confusion. Could you explain the standards the courts apply to determine whether a mark in question is diluted?
Yes, thank you. So under our system, you can bring an action for dilution of a trademark, which importantly is something different than trademark infringement. But this only relates to when a mark is famous. And what we mean by famous is it's a trademark that is basically a household name. It is something that will be almost immediately familiar to almost everyone in the country. So unlike the state of Delaware, where I hail from, and I explained this morning, not everyone in our country could tell you where Delaware is. Pretty much every American knows what Coca-Cola is, or Apple, or General Motors. So what that means is, and the reason we don't have typically a trademark infringement action for a famous mark is there's not usually very much likelihood of confusion. If I make a batch of soda in my basement and call it Coca-Cola, nobody is going to be confused that I actually am Coca-Cola, but I may be causing harm to the economic value of the trademark of Coca-Cola nonetheless, and if they think so, they can sue me for dilution. We have a federal level anti-dilution statute, and it identifies a non-exhaustive list of factors that allow the court to determine whether a mark is famous. These factors include the duration, extent, and geographic reach of advertising and publicity of the mark, the amount, volume, and geographic extent of the sale of goods or services offered under the mark, and the extent of actual recognition of the mark. Those are the factors that go into assessing whether the mark is in fact famous and therefore can be the basis for a dilution action.
Thank you, Judge Stark. I'd like to ask Judge Donggyu Kim. There are some regulations with regard to dilution of a famous mark in Korea. Could you introduce the regulations and practice in Korea on this matter?
Yes. The dilution of famous mark has been regulated as one of the Unfair Competition Act by the Unfair Competition Prevention Act in Korea. However, the Trademark Act has been recently amended to regulate a mark that is likely to dilute other famous mark as one of the grounds for refusal of registration. Dilution of a famous mark means that the unauthorized use of a similar or identical mark by a third party damages the distinctiveness or reputation of a famous mark. To damage it to distinctiveness of famous mark is a similar concept to blurring under U.S. law. It refers to the act that weakens the function of the mark as the source indicator of the goods or services. It is also understood to lessen the famous mark's uniqueness of the association between the mark and the goods perceived by the consumer. It occurs when the use of similar or identical mark by a third party decreases the likelihood that a famous mark will serve as a unique identifier of the owner's goods and hinders the selling power of the owner's famous mark. To damage the fame of a famous mark is similar to the tarnishment under the U.S. law. It means the act that damages the reputation or credit of the famous mark by using a similar or identical mark on inferior or unhealthy or unpleasant goods or services. To deserve the dilution protection, the owner's mark should be famous. A famous mark is well known to the general public, as well as the consumer of the specific goods. And a mark adage is identical or similar to the famous mark. But because the goods or services are in a related market, the likelihood of confusion is not required for dilution. It is arguable whether to need to actual dilution for dilution protection, but if the likelihood dilution is proved, the dilution protection will be granted. Thank you.
Thank you. I'm sorry, due to the time constraint, we should skip the question 2/4 on fake products. I'm sorry. Next question. We have reached the last topic of this session. It's about use as a trademark. The first question is about trademark's relationship with design. In some cases where a trademark at issue contains shapes or patterns, it matters whether use of such a mark is purely for design purposes or for indicating a source of the products. This is because use as a trademark is a prerequisite for a trademark infringement. Now, let me ask a question of Judge Stark, Judge KOKUBU, and Judge Byeongguk Kim. Could you tell us practice of courts in your country briefly on this issue? Let's first hear from Judge Stark.
Yes, thank you. I understand this question to get at what we call trade dress in American law, and infringement of trade dress requires consideration of three elements: validity, lack of functionality, and then infringement. For the first element, validity, the product's design or shape must identify or distinguish a source. So unlike word or picture marks, a trade dress cannot be inherently distinctive. Instead, if it's going to be distinctive, it's going to be that acquired distinctiveness or secondary meaning, which was one of the two categories I spoke about when it comes to word marks. The second element of trade dress is lack of functionality, and that is the asserted aspect of the product's design or shape cannot provide a utilitarian or functional advantage. Where a design provides some utilitarian advantage, the design is not protectable through trade dress law because a function is not distinctive in a trademark sense. Protection of functions is really more the province of patent law. However, a non-functional aspect of a product's design may serve as the basis of protectable trade dress. For example, a wine bottle that has a unique shape, of course, has a function. You don't want your wine just to spill all over the table, but that function does not convey a specific utilitarian advantage, so the shape can be protectable as trade dress. The third element, infringement, requires the plaintiff in such an action for trade dress infringement to show a likelihood of confusion as a result of the design of the defendant's product.
Thank you, Judge Stark. Judge KOKUBU, what is your views on this issue?
Article 26, paragraph 1, item 6 of Japanese Trademark Act stipulates that trademark right has no effect on the trademark which is not used in the mode that consumers can recognize that the goods or services are those pertaining to the business of a particular person. Actually, there are several decisions which have that the trademark right is not effective when use of the mark by the defendant is not for indicating the source of the goods, but for purely design purposes, thereby deny the use as a trademark. In addition, there is a decision which held that the defendant's mark is interpreted as being used as a trademark insofar it is used as a source of indicator when the mark is just pattern.
Thank you. Judge Byeongguk Kim, please share your views.
Thank you. For constitution of the infringement of trademark, the mark of the dependent should be used as a trademark, which that is to say, the mark functions indication of the source of the goods. And it's quite often that the dependent claims that the mark used by the dependent solely plays as design. There are many, on this issue, the practice of Korea is clear. The function of as a design and the function as a trademark or the source, indication of a source of goods is compatible. So the mark can be used as a design as well as trademark simultaneously. There are, as shown on the slide, there are many interesting cases with this issue, and let me briefly introduce the three interesting cases. The first one, the left side is the actual product of the dependent, and the In case one, do you see whose goods is this one? It's is sold by the Swarovski, which is a very well-known company for the crystal product. And this company happened to manufacture and sell a series of crystal products comprised of diverse shapes of animal, and one of them was like this. It looks like puppy. And the right side is the mark owned by the trademark. Do you know whose mark is this one? Agasa, which is a very well-known company of France. And as you see, the defendant of the Swarovski claimed that this crystal product, the shape, this mark, it's not mark, it's just design, and it's not used as mark. And there was inconsistent decisions among the courts. The first instance court decided that this mark looks like design, but it functions as a trademark as well. So the first instance court accepted the claim by the plaintiff. On the other hand, the second instance court, the Seoul High Court, remanded this decision on the ground that this shape, this crystal, the shape is only praised as a design. It doesn't praise as a trademark at all. So there is no infringement of trademark. And the Supreme Court supported the decision by the Seoul High Court. There is a very interesting behind the story. I happen to belong to the first instance court, and I tried this case by myself. And Judge Donggyu Kim, happened to be the judge of the Seoul High Court. He made a better decision than me, as long as this case is concerned. But I think this phrase as a trademark. The next case and the third case is regarding very well-known trademark holders. The defendant sold the shirt, in case 2, sold this shirt with this pattern. And in case 3, the defendant sold the pottery with this pattern. I think you would be well aware whose pattern is this one. And the court decided the same conclusion that even though this looks like design, it plays as the indication of source, so there is infringement. Thank you.
Thank you, Judge Kim. I heard Mr. Saintville is a co-author of a famous book on design rights. So if you don't mind, may I ask you any opinion on this issue?
I'd welcome the opportunity to. I'm not going to touch on design cases directly, but stick to trademarks and consider this interaction with whether you can register something that looks a lot like the design of the product as a registered trademark. And to understand that, you need to understand the way the exclusions work in the European trademark regime. Signs which consist exclusively of the shape or other characteristics which result from the nature of the goods themselves can't be registered. Signs which consist exclusively of the shape or another characteristic of goods which is necessary to obtain a technical result can't be registered as trademarks. And shapes which consist exclusively of the shape or another characteristic which gives substantial value to the goods can't be registered. And those are exclusions that can't be overcome by use or gaining distinctiveness, because the policy behind those exclusions is different, that you shouldn't gain a monopoly, which could be indefinite, over the technical features of a product or things that give it its substantial value, or over the shape of the goods themselves. And I'd like to talk about that by reference to a couple of examples that involve the famous Lego company and their toy system. And in his answer, Professor Jacob offered some examples from a PowerPoint presentation which doesn't appear in the book, so I thought I would show you some of the pictures, and I'll start off with a little bit of prejudice against Lego, which is best introduced by starting off with a picture of the children of a chap called Hilary Page from 1949, his two twin daughters, playing with his company, Kiddicraft's building block system. And the Kiddicraft building blocks looked like this, and they came before Lego. And they were the subject of a patent application in 1939 that had that illustration about its features. Notice a patent application for functional technical advances, and a later patent of addition. As Kiddicraft passes out of the picture and Hilary Page passes away, Lego produced a system that's acknowledged, at least on the Wikipedia page for Hilary Page, to be derived from the Kiddicraft system. Nonetheless, they apply for this as a registered trademark. So that's an image of a Lego block. And the question is, can they obtain that permanent monopoly? Because that is an indication of the origin of their trade origin of their goods. And the analysis that's required is this a shape which is necessary to obtain a technical result? And they argue, no, interlocking bricks and other shapes can be made of in other shapes, and it's not, therefore, it's not necessary to use this particular shape to achieve a technical result. Now, that argument is an important one in European trademark law and design law, because it's rejected. It's called the multiplicity of forms theory, the idea that if you can have more than one form, then no particular form is necessary to obtain a technical result, and it's rejected. But notice that you might say, well, that's a shape that results from the nature of the goods themselves as well. The reason I say notice that as well is here's another example of a trademark that Lego managed to keep on the register, because the General Court of the European Union reached the conclusion that it wasn't excluded based upon the arguments put before it. And what it actually shows is the real importance of putting all of the grounds for keeping a registration off the register in front of a tribunal, and evidence to support that point. Because you might ask yourself, well, what aspect of this mark is not the shape or another characteristic which gives substantial value to the goods? But that was not a point that was run. And it was held that the holes in the feet weren't shown to be necessary to obtain a technical result because of the lack of evidence, even though all of us know that that's exactly what you use to make Darth Vader stand on the deck of the Millennium Falcon.
Thank you, Mr. St. Phil. Now we reached the last topic, keyword advertising and domain names. As one of newly arising issues, the next question is whether search keyword advertising can be viewed as a trademark use. it would be great if Judge Stark and Mr. Saint-Phil can share opinions on this question with us. There's a case where when an ordinary user enters a keyword identical or similar to a registered trademark in the search box, the search result does not display the website of the trademark holder, or it shows the website addresses or links of the person who has purchased the keyword from the platform operator, along with the trademark holder's website. One of the issues in this case is whether the entire process of entering a keyword, searching, and displaying the search results can be viewed as a trademark use. Could you share the practice of the courts in your country on this matter? Let's first hear from Judge Stark.
Yes, thank you. This is an increasingly arising issue as, of course, much commerce has moved over to the internet. In our country, we don't have a specific statute that relates to this, so we apply our same actual confusion, or more commonly likelihood of confusion test. I've not seen the issue yet in my courtroom, but from my research, my understanding is that most courts confronted with the issue first with keyword advertising have found that keyword advertising based on searching a trademark as your search term. So you type into Google the word Volkswagen, for instance, and what you get back is not necessarily just hits related to Volkswagen, but also some for Toyota or Hyundai or whatever the case may be. Most courts are finding that that is a use in commerce, which is the phrase that our Lanham Act turns on, and therefore is protectable by the possibility of an infringement action. However, it also appears that most courts are finding that there is no infringement on the merits because there's not generally any likelihood of confusion. When the user types in Volkswagen, even if they get back results that don't relate directly to Volkswagen, it's very unlikely that they're confused by what happened. It's just sort of inherent in how, for instance, Google works when you type a word into a search engine. So that's how it appears we are handling the keyword advertising. It's similar for domain names. Most courts appear to be saying that a domain name can be a use in commerce and therefore is potentially a protectable mark. But it also, if someone controls the domain name that consists of the mark and that someone is not actually affiliated with the owner of the mark, it's very unusual so far that anyone is being confused by that. So typically, someone we're finding is buying the domain name containing someone else's mark because they want to, for instance, criticize the company. So if I bought the mark for Volkswagen, or if I bought the domain name for Volkswagen, and when someone types in Volkswagen into Google, they get some website that's all about how terrible Volkswagens are, no one's generally very confused by what's going on. They don't think that my website really is related to Volkswagen. So it is being viewed most commonly as a use in commerce, therefore within the scope of protection available under the Lanham Act. But so far, courts are not finding fact patterns that suggest actual likelihood of confusion and therefore no infringement on the merits.
Thank you, Judge Stark. Mr. Saint-Phil, is there anything you would like to add to this issue?
Yet we have quite a developed case law in the UK and the European Union on both of these subjects. The question of search engines has been the subject of leading cases in the European Court of Justice and after references to the European Court of Justice in our Court of Appeal. And to understand how the law works, you need to have in mind our three categories of infringement. The first of which is the use of a sign which is identical with the trademark and is used in relation to goods or services which are identical for which the trademark is registered. And the Court of Justice has developed a doctrine that says that in order for there to be infringement, you have also to affect the functions of the trademark, or one of the functions of the trademark, such as its origin function or its advertising function, and so on. And that's important when we come back to the detail. The second kind of infringement is use of an identical or similar sign in relation to identical or similar goods to those for which the mark is registered, such that there is a likelihood of confusion on the part of the public. And the third type of infringement is use of a sign that's identical with or similar to the trademark in relation to any goods or services where the mark has a reputation in the member state for a national trademark or in the European Union for a European Union trademark, and where use of the infringing sign without due cause takes unfair advantage of or is detrimental to the distinctive character or repute of the mark. So it's free riding, or it's tarnishing, or it's diluting the trademark in that third kind of infringement. All can come into play in this arena, but the key one for analysis is when it's an identical mark used in relation to identical goods, and there the courts have been clear now that when people are bidding for the use of signs in relation to AdWords in search engines, so you enter into a search engine and you get an advertisement for a competitive set of goods, then that is use of the sign in relation to goods and services by the party bidding for the ad word and advertising. But it is not use of the sign by the search engine operator, because they aren't using the sign in their trade, and it's not use of the sign by the user typing into the computer system. And then there is an additional layer of analysis, because then when you ask the question, is that affecting the functions of the mark? Is it affecting the origin functions of the mark? A test has been laid down by the European Court of Justice that where the advertisement doesn't enable an average consumer, or only enables the user with difficulty to ascertain whether the goods or services referred to originate from the proprietor, then there is an effect on the function of the trademark and therefore infringement. So it's a kind of diluted confusion test, that if you don't stop there being a risk, or you don't allow the person to know without difficulty that the goods are originating from someone else, then you are infringing. That leads to numerous examples of infringement in those circumstances, those kinds of circumstances. Our case law in relation to domain names is really quite straightforward. A domain name is often used as a trademark. If somebody hijacks a trademark, then that's going to be trademark infringement by the act of registration. It's also likely to be actionable in the common law law of passing off, both because it represents a misrepresentation to members of the public as to the source of goods or services, and a threat to make misrepresentations, and creating what's called an instrument of deception, an area of law that was developed in the 19th century to deal with false labels being shipped around I guess what was then the British Empire, to sell whiskey and so on. False whiskey labels were instruments of deception, and making them in the UK was a completed wrong in passing off. The same goes for acquiring a domain name for that kind of purpose. So you have to have some real legitimate purpose to be operating in parallel with someone, and often people who set up complaint sites are successfully sued in the UK, not least because interim injunctions only need an arguable case, and the cost of litigation then put people off.
Thank you, Mr. St. Bill. I'm sorry, but due to the time limit, we have to skip the last question. Defenses in trademark infringement lawsuits. I guess you have received a text message regarding 5 short questions before this session started. Before we wrap up, should we find out about the survey result now? That's interesting. Well, it's a little bit different from the speaker's responses. But everyone has different views. So everyone can have different opinions about trademarks. Thank you all for your responses. Thank you very much for preparing for and participating in this great session. Once again, please give a big round of applause to the panelists for their lively discussion.
Thank you very much, all. That was a great session.
Thank you very much again.
We are going to take a break now until 4:30 p.m. Please return to your seat before then.